Let's go to this now. As the country approaches the 10th commemoration of the Marikana Massacre, the Solicitor-General yesterday gave an update on the progress regarding claims. This process has been dragging on for years now, and government hopes to have all these claims finalised by the end of August. Fhedzisani Pandelani Solicitor-General joins us live now. Thank you so much for your time this evening. It's around 370 claims, if I understand, in total, divided into 3 categories. Briefly tell us how far you are with these.
No, thank you very much for having me, and greetings to your listeners, your viewers. It's actually 379 in the last count, and of all of those claims, only 48 in our books remain to be settled. These are the matters that the court is currently seized with. Effectively the 25th to the 25th of July up to the 19th of August has been set aside to try and finalize these particular matters that I'm referring to, which is the last category.
And when we talk about these 3 categories, it's the loss of support, of course, loss of life, malicious prosecution, personal injuries, as well as some special damages. Is that correct?
Yes, true. So the first category is that which relates to where people have died, where there's loss of support, and those who have dealt with, as you would recall, from our report last year, as at that stage, we've already finalized those. Then category B would deal with arrest, detention, and those that claim to have been assaulted. We dealt with a huge bulk of those matters. Category C remains those that are now being judicially managed under the auspices of the High Court in Pretoria.
And why do things have to get to court, would you say?
Look, if you look at all the other matters, bar the 48 that you are referring to, all of those matters were finalized via negotiations. None of those matters served in court. So the bulk of the matters from the 379 would have been finalized through a process of negotiation, of mediation, of trying to reach each other and find each other insofar as the quantum is concerned. Now, in relation to the 48, these relate to serious injuries, if you may. These would have been some of those minors and others who were hospitalized for extended periods of times in certain instances. And in relation to those matters, which in fact have got an element of general damages, which is pain and suffering, as well as special damages, you need then to have reports relating to the extent and nature of the injuries, so that you can then make a determination of a compensation that is fair, just and reasonable. And that is in fact inherently something that in fact took longer than expected.
And where would you say, though, that you were missing each other as the parties for you to, reach a point where, I'm going to borrow from your words yesterday, to have an umpire to now come in and be able to help the 2 parties settle these particular matters? Where were you missing each other?
Look, litigation by its own very nature is very difficult. You probably would want to get a certain amount of money that you are claiming, and the other party believes it cannot be justified, it's unreasonable, and therefore you start haggling around what is fair and reasonable. And oftentimes in litigation, experts in fact get to be called. So the delay in the majority of these matters where we were not being finished with the necessary reports to sustain the kind of claims that were being proffered against the state. And that is where the missing link was.
And did also the fact that, some of the policies also were not in place when it comes to the length of time, because people have been asking, it's been 10 years, nothing, very little has been done. But, as you started off by saying in your briefing yesterday that, there has been work that has been done, but also some of the policies or non-existence thereof were also making things difficult.
Look, I mean, the state can still operate with or without the policies because the Constitution applies both vertically and horizontally, which means the state, in fact, also is bound by common law as applicable. Now, the policies that I referred to are an added layer to make sure that we, in fact, have a capable state. So the state could still, in fact, proceed to litigate in terms of the common law as we understand it. But what I'm actually bringing into this environment is the agility that, in fact, the state needs to be invoking in dealing with these matters so that we can avoid delays and so on and so forth. And take into account the fact that those policies are not policies that are cross-cutting. They don't actually bind the public institutions or the private institutions, as it were, or private litigants. It is, in fact, intended to make the state more agile, more responsive, and also to reduce the cost of litigation insofar as taxpayers' money is concerned.
You spoke about hoping to finalize all of these by the end of August. Is that still a possibility? Because some are saying it may not necessarily come to fruition.
You're talking about the matters before court or the policies?
The ones that are before court.
The matters before court. Look, I mean, I think you will appreciate that, settlement by its own very nature takes two individuals or more to reach each other. So if you are going to have a party that is already upfront is saying, we don't believe these matters are going to settle, then you've got an element of bad faith. And bad faith in itself is destructive to settlement of matters. So I'm here because the state has made offers. It's not a situation where we are saying the state is still going to think about what needs to be offered in relation to each particular case. We have made those offers, and those that believe that they want to string this thing for another year or two, then they will have to do that at their own folly, because it is not because the state is not coming to the table. The state is coming to the table and making an offer, and that is where we are. So the question is, am I comfortable that the state has done all and everything in order to settle these matters? Yes. Is the other party willing to accept the offers that are being made? Because it entails offers and acceptancy. Now, if you don't accept, I can't help that situation. It means the court will then have to be seized with the matters. It will have to appoint a judge, and then we'll have to go through the whole process of having to lead evidence via witnesses without the possibility of the matters settling and actually freeing the court from the shackles of having to sit and decide matters witness by witness. I mean, currently, it takes almost more than a week to lead one witness. Now, you can imagine if you've got 1,001 witnesses in all those matters that might be remaining, it could be possible that, in fact, you might string it to 2023, 2024. But it is not because of lack of trying on the part of the state.
And very briefly then, as a final question, you mentioned something very critical, and I'd like you to end off with it. I mean, there are some family members, for example, who lost their loved ones in the tragedy, and they've not put forward claims. And they're wondering why they're not even receiving the compensation. What do you say to them very briefly tonight?
Well, as I sit right here, I actually was engaged in a closed-up session with all the families, all of them, even those that we have paid before. I'm just from a meeting at Constitutional Hill where, we were sitting and deliberating on these issues. I must also state that some of them, in fact, said they waited for the Falam Commission to come to an end, and they've not actually been able to claim because of prescription. Prescription is 3 years. Now, there is a process which I'm going to do a report about, and that, in fact, will have to take these matters off the common law principles as you understand them. It depends on the principals whether they want to entertain those claimants that, in fact, have never lodged any claim in the spirit of humanity. But then again, we keep on talking, when we talk about loss of life, we keep on talking about the 34. And these 34 would have been those that were AMCU members. And no one talks about the other 10 that might have been police or the security guards. So I had the benefit of having to sit face to face with them, see some of them crying, and had to empathize with them. And this is a report that, in fact, I will take forward because it is not before court. This is a process that might have to be dealt with from a political point of view.
All right, let me thank you for your time, and we look forward to your report then to see what is going to be agreed upon, and we're hoping to speak to you then when that report is out. Thank you so much for your time this evening. That's Fhedzisani Pandelani, the Solicitor General.